Welcome back, everybody, to another I'm gonna get fired from my job, Your Honor. I can't go to jail. Episode of Lockdown 23 and 1. That's right, today we're going to witness an individual get sentenced for violating a protective order. But there's a lot of logistic twists and turns to this episode that I like to break down. Not to mention the ending of the defendant snapping on the judge. It was completely unexpected, but highly entertaining. Disrespectful, though. Smokeville antics. So let's get right into it, ladies and gentlemen. If you enjoy all things lockup and crime related, then this is where you want to be. Hit that like, subscribe, notification bell before you leave, and check out my playlist with many more videos for you to start watching today.
Mr. Church and Mr. Cooper, we're here on a motion filed by the prosecutor's office. That motion is to revoke bond. I had an opportunity to review the motion. I did not see any filed response. Did you file any response, Mr. Church?
I did not. I was just served the motion late last week, and unfortunately, as the court's likely aware, I've been in court all this week.
Ms. Brooker, your motion.
Your Honor, as the information in the motion states, we have a documented report from the Clare County Sheriff's Department of Mr. Cooper having contact with the victim in this case, who is the protected party. He's had bond conditions in place prohibiting him from having contact with her since the beginning of this case in 2022. So we are asking this court to sign a bench warrant and revoke his bond pending trial.
One of the many things the court does not look highly upon is individuals violating protective orders. Man, oh man, that's like not showing up to probation. So if I were to guess, he's definitely going back to jail. Unless maybe he has a good excuse. Sometimes it works like that. Judge takes certain things into consideration, gives him another slap on the wrist. But down here in the bottom right corner is the defendant's attorney, in case you didn't know.
Mr. Church?
So, Your Honor, a few things. One, I think that the alleged victim may be logged into Zoom and be present, and she may want to address the court on this. Secondly, our response to this, we don't dispute that there was contact that occurred. This is a situation in which there was confusion on Mr. Cooper's part. He had a case out of here from 2020. There's also a case that arose out of Clare County. In Clare County, there was a no contact provision. They went to the court in Clare County, and that no contact provision was removed. He did not understand and recognize that there was still a no contact provision here. And that's, again, why I believe the alleged victim is present, and I would ask the court to consider talking to her about it. I don't think there was anything in regards to the contact that's alleged to have been violent or even unwanted. They just simply didn't realize.
She is not present.
Okay. Again, I think this is a situation where they just did not realize this provision was still out there prohibiting that contact.
The court finds you in criminal contempt based upon those statements, Mr. Cooper. You're entitled to a hearing if you want to challenge the allegations, but it does not appear that you're challenging that you were in contact with Ms. Dinizone, however I pronounce her last name. So, Mr. Church, I'll provide you a hearing, and we'll have it right now if you want to have that hearing. But I intend to find Mr. Cooper in indirect criminal contempt of court based upon a clear violation, and I do not accept any confusion that was suggested or implied.
All right, so believe it or not, there's a lot to unpack here. Because typically a defense attorney's not going to ask the victim to come out and speak unless they're going to be speaking good on the defendant. And situations like that are usually related to relationships, boyfriend, girlfriend, husband, wife. Second of all, the defense attorney, I don't know if he meant to do this or not, but he's pretty much already said, hey, we're not disputing that he had contact with her. We're just saying it was an honest mistake. Well, playing by the book, he technically confessed to the violation of the protective order. Ain't really nothing he can do to fight it now, but maybe that's what he wanted. He knows it's a one-way in, one-way out cul-de-sac, and the only route leads to jail. So he weighed his options and said, probably throwing himself at the mercy of the courts, letting the victim speak on the defendant's behalf, might persuade the judge to, even though he's guilty of having contact with her, not give him no time, right? I think that's the route the defense attorney's taken.
This case has been pending for years. It's very serious in nature, as Mr. Cooper is well aware. He's charged with a 10-year felony as a habitual fourth. He knows very well what the charges are and what the maximum punishment is. It's also very clear to me that there has been multiple problems on bond. And so with all of that backdrop, I do not intend to ignore this or excuse it as a mistake or misunderstanding, because it does not appear to me to be that. And so my intention is to impose a short period of jail as a result of the violation if in fact I find Mr. Cooper guilty. Again, fundamentally, based on what you've told me, Mr. Trush, I don't expect that you will want a hearing because you've acknowledged that there's been a violation. But if you want a hearing, you're entitled to it.
So the judge is saying, you can go ahead with the hearing, but you pretty much already admitted to guilt, like I just got done speaking to y'all about. But this is the thing. My boat was kind of steering in the defendant's direction, right? Yeah, that kind of makes sense. His protective order was up in one county, and it was an honest mistake. He thought it was up in the other county as well. Stuff happens like that sometimes, and, it could get confusing. Lose track of the court dates or whatever, but the judge said something that steered the boat in a totally different direction. This dude is a 4-time habitual offender with past issues on bond. I'm sure there's plenty more on that paperwork the judge read that makes him feel as though this dude's lying and knew exactly what he was doing, right? So that's why I like the courtroom, man. You can start believing one way, and then you hear someone else speak on the situation like the judge or the prosecutor, and it would change your whole outlook on everything. Crazy, right? Words, they're powerful.
My intention would be to put Mr. Cooper in jail for probably 10 days as a result of the violation to re-encourage him to understand the exact provisions that he is in violation of and that he is bound by. I would then intend to reinstate bond after that 10-day period. If you're willing to accept that, that's fine. If you're not, we're going to have a hearing. But that's my intention because it is absolutely clear to me that Mr. Cooper was aware, despite your protestation or his protestation, that you misunderstood. This matter is not acceptable to the court for so many reasons. So, Mr. Trush, did you need a moment to talk to Mr. Cooper about his desires or his plans going forward?
So, Your Honor, if I could make a suggestion to the court,
Well, you can't make a suggestion to me, but you can certainly take me up on my offer to talk with your client, or just proceed however you want to proceed.
No suggestions. The only thing you need to suggest is to your defendant, 10 days in jail or not. Oh man, this dude is as good as smoke. Bobby, tap it one time, warm him up. Yep, it's starting to smell like a charcoal brisket in here.
But I'm not going to take suggestions at this juncture.
And Your Honor, what I meant is in terms of how to proceed going forward. It was our intentions today to offer a plea in this case, and I would suggest to the court that in terms of procedurally how to proceed, if the court would consider setting the sentencing and the contempt at the same time, I think and it would give us an opportunity to present the court with some of the information that I think, again, not necessarily in terms of, not necessarily in terms of the contact, but how the court should respond to that.
All right, so we got some twists and turns here. The defense said that he has a plea deal for the case at hand, which is, I don't even know what the charges are that he violated the protective order on, but he's trying to do both of them at once. This case was from, 2020? He's still out on bond for it? Yeah, let's do the plea deal and get sentenced to both of them at the same time. But in order for him to have a plea deal to give to the courts, that means the defendant is in agreement with it already. So I don't know, man. Let's find out if the judge is going to agree to sentence them both at the same time or what.
Well, I know how I'm going to respond to it. I've already told you how I'm going to respond to it, and today is the day for the motion. There is no question that there's been a violation. The only question is how I should proceed. And again, you can make your arguments, and I'll hear them. The prosecutor can make her arguments, and I'll hear them. I would imagine the prosecutor is going to ask for more than what I've told you I intend, and I imagine you'll ask for less. I'll balance those things and ultimately come to my conclusion, but today's the day that's going to happen. If you want to also enter a plea agreement today, that's fine. But my intention remains the same, again, understanding that I'll give you the opportunity to argue.
Your Honor, then I would ask that we be permitted to tender that plea. And then, again, I would ask the court to check. I think that the alleged victim is now in the waiting room.
Oh,
I would ask the court to check on that as well.
She is in the waiting room, but at this point, Mr. Trush, I don't intend to hear from her because at this point, this is not an evidentiary hearing. And based on what you've told me so far, none of what she would say would have any effect on anything because even if, for example, I believed and Ms. Gidnazone told me that she thought there was something dropped, that does not make any difference because it was not dropped. And there should have been no misunderstanding of that on Mr. Cooper's behalf. And so while I understand that you would want to offer her, this is not an evidentiary hearing. You've not demanded one and you've made concessions that there was violations. And so anything that I would hear from Ms. Gidnazone would ultimately not likely have any impact on my exercise of discretion. And so while I recognize you would want me to hear from her, I'll hear from her as the law requires at a sentencing hearing, but not until.
Well, that's not good. Don't even care to hear what the victim has to say. It's already set in stone for you, buddy. But maybe he's just speaking about the, violation of protective order thing, contempt of court situation. When it comes down to the plea deal, I think it would be important for the judge to hear what the victim has to say when it comes down, of course, like you said, the sentencing, but not so much for this sentencing when it comes to him violating the protective order. I know it's getting kind of confusing, but it's what happens when you keep going back to the same girl and getting in trouble over and over again.
Your Honor, I don't want to lose my job. Is there any way I can go upon this?
I'm not going to hear from you right now. I'm going to hear from your attorney for a variety of reasons, most importantly, which is you're still facing life in prison for this underlying offense, both underlying offenses. And so until I hear whether or not you plan to enter pleas and then what the nature of those pleas are, I'm not going to hear from you. I understand why you would want to be heard, but I'm not going to hear from you irrespective of that desire right now. Mr. Trush, what is the plan in terms of a plea offer that's been proposed?
Yes, please,
So,
please.
Your Honor, we are going to receive a plea offer where if Mr. Cooper pled to an added count 2 possession of, pled to count 2 possession of an added count 4 domestic violence first offense, the remainder of the complaint would be dismissed.
So that would be a domestic violence 93-day $500 maximum. Is that right?
Yes, Your Honor.
So it sounds like he has a list of charges, but if he pleads guilty to count 2 of some felonious inebriants, and it sounds like a misdemeanor domestic violence, because he said it can only get a maximum of 90 days, and I think that's misdemeanor time, of course. First offense, domestic. Okay, so he has habitual offense, probably from the inebriants or just felonies in general. Either way, the habitual is going to give him a higher sentence regardless. Always does. It's like a gun enhancement, gang enhancement, stuff like that. Normal crimes, if you weren't part of a gang, you get less time. But since you're part of a gang, you're getting more time. Since it's your first offense, you're getting less time. Well, it's your fourth offense, you're getting more time. You see how it works? That's how it works.
Is that right, Mr. Trush?
That is correct.
Mr. Cooper, did you hear the terms of that plea agreement?
Yes, Your Honor.
Is that how you wanted to proceed, is by accepting the terms of that plea agreement?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Mr. Cooper, under this plea agreement, you're offering to plead guilty to count 2, which is entitled controlled substance possession of methamphetamine. That offense is a felony offense, and the maximum potential punishment for that felony is up to 10 years in the state prison system and or a fine of up to $15,000. You're also offering to plead guilty to what's called an added count 4. That added count 4 is known as domestic violence. Domestic violence is a misdemeanor offense, punishable by a maximum of 93 days in jail and or a fine of up to $500. If you plead guilty to those 2 offenses, possession of methamphetamine and domestic violence, the prosecutor would then dismiss count 1, the assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, controlled substance possession of the controlled substance buprenorphine, as well as the habitual offender 4th offense notice, which, as I've stated before, could have the effect of elevating those 2 first offenses up to life in prison.
Man, oh man, ladies and gentlemen, this is a prime example of why people jump on those plea deals so quick. Because this one's sweet. Regardless of how much time he's going to get for it, that doesn't matter. They said plead guilty to those 2 charges that we already spoke about, and they'll drop the first one, which was a felony assault strangulation. And that being on a woman, man, is something you do not want on your record. With that kind of paperwork in some cell blocks in some prisons, it's a damn death sentence, right? So, pleading guilty to these other 2 charges, they're going to drop that serious one. Not to mention the habitual, which cranks those other charges up to a life sentence. If he doesn't take the plea, then he's going to face all of it. It's a scary situation, but like I said, it's pretty much a no-brainer. Plea deal 100%. Can't risk having that felonious assault on my record. And I ain't trying to risk going to prison for life. Let's find out what he's going to do.
Are you aware of the terms of the plea agreement?
Yes, Your Honor.
Did you want to take advantage of it by entering pleas to count 2 and count 4?
Yes, Your Honor.
Do you understand the maximum penalties that you can face for possession of methamphetamine and domestic violence?
Yes, Your Honor.
Do you understand the benefit of the plea agreement that you get in having count 3, count 1, and the habitual 4th dismissed?
Yes, Your Honor.
If you plead guilty, Mr. Cooper, you will no longer have any automatic right to appeal. Do you understand that?
Yes, Your Honor.
So what that means is following any plea, your appeal rights are limited. You would have to ask the Court of Appeals for permission to appeal. It's not an automatic right. You understand that?
Yeah, yes, Your Honor.
As to the count 2 possession of methamphetamine, then what is your plea?
I'm sorry, Chair. Is it no contest or guilty, Chair?
Well, guilty is what was described to me, and guilty would simply mean you tell me why you're guilty of the offenses. Is that what you intend to do?
Yes, Your Honor.
How do you plead to domestic violence in count 4?
Guilty.
If you plead guilty, you also give up all of your current trial rights, including the right to trial itself. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you'd have a right to remain silent, not have that silence used against you, and you would have the right to testify at trial if you wanted to. Further, at your trial, you would have a right to have the witnesses against you appear and to see, hear, and question them. And you would have the right to have the court order any witnesses on your behalf to appear at trial. But if you enter a guilty plea, you lose all of those important trial rights. Are you aware of that?
Yes, Your Honor.
And because you're giving up your right to the trial itself, you also necessarily give up the right to challenge other things that could have happened at the trial. Are you aware of that?
Yes, Your
That was a
Honor.
question.
Sorry.
Do you have any questions? That last warning?
What was the last part? I'm cutting out. I'm
Do you
sorry.
have any question- Do you have any questions about that last warning that I just provided?
No, Your Honor.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
Imagine pleading guilty to domestic violence, but the victim's there to speak on your behalf. That's what these plea deals do, man. Let me know what y'all would have done in this type of situation.
Your choice to plead guilty.
Yes, sir.
Court notes then that the prosecutor charges that this happened on or about February 23rd of 2022. Does that sound accurate?
Yes.
On that date, were you located here in Otsego County?
Yeah.
And on that date, did you knowingly or intentionally possess the controlled substance methamphetamine?
Yes, Your Honor.
And did you have any legal authority to possess it at that time?
They obtained it from my lot container, Your Honor.
My question to you was, did you have any legal authority to possess it at that time?
Did they gather my substance?
No, bro, no.
Did you
No.
have any legal authority to possess the substance at that time?
I believe so, sir.
Your
Think
Honor,
you had
I think he can hear
authority
you.
to possess methamphetamine?
I'm sorry, I can't understand you. It's bad connection.
So let me speak up then. The question that I asked is, did you have any legal authority to possess the methamphetamine on that day?
No, Your Honor. I misunderstood your question.
Oh, man.
That's okay. Is it also accurate that on that date you were or had been in a dating relationship with?
Yes.
Did you commit an assault upon her while you were in that dating relationship?
You don't want to say yes to that.
I'm sorry, I don't know what I'm supposed to say from here, Your Honor.
Well, it's pretty simple, Mr. Cooper. You're offering to plead guilty to domestic violence.
I don't know who's that peeking in the back throughout this whole video, but if I were to guess, it's probably like his mom or something, new girlfriend, I don't know. Either way, he's looking at the person like, am I pleading guilty? I didn't do shit. But whatever, I don't want strangulation. This game is crazy, man. Stay the hell out the court system, y'all.
I'm asking you if you committed domestic violence. So either you did or you didn't.
I admit that there was a domestic violence.
What was a domestic violence?
A disagreement
What disagreement?
upon us being homeless.
What did you do that makes you think I should find you guilty of domestic violence?
We got into an argument, Your Honor, And
I
there's
don't
some,
want to hear about what we did. I want to hear about what you did.
I raised my voice and started yelling at her.
Do you think that raising your voice is domestic violence?
That's what I'm here for.
Oh, no.
Let me tell you what the law provides, Mr. Cooper.
He thinks he's in here for yelling at his old lady, man. This is sad. Taking plea deals and everything. This guy, either he's clueless or he's trying to play the system.
Because it's relatively clear, and I'm relatively clear. The reason I sound rather perturbed is because I am. Because I think you clearly understand what domestic violence is and what it's not. What domestic violence is an assault. An assault cannot happen by accident. And an assault and or an assault and battery is where you physically touch against somebody's will that person. So did you do that or did you not do that?
I did not touch Brooke in a harmful manner.
Then I reject your plea agreement, Mr. Cooper, because it's clear to me that you are not acknowledging that you are guilty. If you're not acknowledging that you're guilty, you can't plead guilty.
Oh, there goes that sweet muffin plea deal. I would have switched it up so quick. Your Honor, yeah, I did. I beat her left and right. I'm just playing, man. But that would have gotten the plea deal good, right? It would have proved his guilt.
And so I will not accept your plea agreement.
Oh,
What I'm going to do
man.
instead is issue the findings that I've already indicated, which is based upon the statements that have been made on the open court record so far, I find you in indirect criminal contempt. And what that means is I find that there's clear evidence that you're in violation of the bond order. That violation of the bond order gives the court two important and distinct possibilities. One distinct possibility is that I could cancel bond altogether. I choose not to do that. I choose instead to treat the violation of bond as indirect criminal contempt. When I choose to do that, that opens up the possibility for me to consider jail up to 93 days, but I do not consider that as the sanction. Based upon the history of non-appearances and prior bench warrants and the length of this case, based upon all of the things I've already stated, it's my view that 10 days of jail is appropriate. But before I finalize that sentence for the indirect criminal contempt that I found, I'm going to hear arguments from the attorneys.
Man, oh man, the judge is playing by the book to the T. He ain't going with the plea deal because obviously the defendant's lost as to what he's even guilty for. So he's going to continue with the original plan, find him guilty for the indirect contempt of court, and he saved him by doing that because he can keep him on the bond. Right? So even though it seems like the judge is being extremely tough and one-sided, he's actually looking out for him.
I'm going to impose that sentence with the indication ultimately that after that sentence is done, you will have your bond reinstated on the 10th day after I issue the sentence. Ms. Brooker, did you wish to articulate any reasoning in support of what you're asking for outside of what the court has suggested?
Your Honor, is there any way I can just plead guilty?
You can in a moment once I hear from and address the other issue that we're here for, Mr. Cooper. Ms. Brooker, did you have anything further you wanted to argue or anything at all you wanted to argue on behalf of
He's going to
people
change it
regarding
up?
how the court should exercise its discretion?
No, Your Honor, I agree with what the court has proposed, and I'll just stand behind the statements in the motion.
Mr. Church, did you have further articulations for the record regarding what you think I should do or why?
Yes, Your Honor. I'm sorry, Your Honor. So a lot has happened since this case has arose. The court has already kind of alluded to the timeline that this case is old and has been pending for a while. A lot has happened in that time period. Mr. Cooper has gone to and completed a rehab. He's gone to and completed some counseling in regards to relationships. I think that the court should take into account those things when looking at how to address this situation. Again, a lot has changed since this has happened. He's fully employed. He's completed a substantial amount of counseling, frankly, probably the vast majority of the counseling the court would likely be seeking to impose on the underlying sentence. So again, I would just renew my request that the court withhold making a judgment as far as a sentence on this until it can, until we can effectuate that plea and be here for a complete sentencing on the underlying matter and address this issue to the court.
Mr. Cooper, you're popping in and out of my screen. I need you to turn your video on.
Don't hide from the courts.
The phone keeps going black, and then I have to touch it.
Mr. Cooper, a moment ago when I was speaking, you asked if you could consider continuing the plea. Is that what you wanted to do?
Yes, Your Honor.
Oh, no.
Do you recall the nature of the plea agreement, the benefits to you, and the drawbacks?
Yes, Your Honor.
Oh, no.
Do you have any questions about any of those things before I hear more from you?
No, Your Honor.
So where we were at in the situation was I was asking you why I should find you guilty of domestic violence. Do you want me to find you guilty of domestic violence?
Do I want you to find me guilty?
Right. Do you want to take advantage of the plea agreement, which means I find you guilty of domestic violence?
Yes, Your Honor.
God.
How should I find you guilty of domestic violence after what you've told me on the open court record and under oath?
I apologize. It's my criminal mentality. It's almost like a reflex, Your Honor. I apologize.
So what actually happened?
We got into an argument, and she pushed me, and I pushed her away.
He knew he put his hands on her, man, in some kind of way. He ain't new to this game.
So you're claiming self-defense?
It was more of an act of aggression than self-defense.
So when you were actively being aggressive, is that what you mean?
Yes, Your Honor.
When you were being actively aggressive, did you physically put your hands on a person that you were in a dating relationship with?
After a few things happened, ultimately I was trying to comfort her, but yeah, it turned relatively.
Mr. Cooper, we're done with the plea proceeding. I will not accept waffling. And what I mean by waffling is you not accepting responsibility for what you're telling me you're guilty of. And I don't care, Mr. Cooper, you need to stop and listen for a minute. It does not matter to me. It does not matter to me in one way or the other what you decide to do. You are entitled as a matter of constitutional principle to a jury trial, and I had it set for you. I'm going to get those dates set for you if that's what you continue to want. Or if you decide that you want to enter a guilty plea, we can go down that path. But I will never, not on this date or on any other date, accept a plea from you unless the terms of the plea are clear. And the terms of the plea can only be clear for a domestic violence offense if you tell me that you're guilty of domestic violence for intentionally striking somebody that you were in a dating relationship with, or something similar that would meet the statutory definition. I am not going to permit a record to be clouded with your definitions or your insertion of words that don't make those things clear. And so in my discretion, I'm not going to continue to. What I am going to do is impose sentence, as I've previously indicated. Your attorney is correct to suggest that I should take all sorts of things into account, and I do. More specifically, Mr. Cooper, at sentencing, I would absolutely take into account if you have been and show me proof that you've been through counseling, because that would tend to mitigate any potential risk of harm to Ms. Goodison. But again, right now, I'm not finding you guilty of domestic violence, and I'm not finding you guilty of possession of methamphetamine. You remain not guilty on those matters because I have not accepted your pleas. That means you will decide how you want to proceed in the future. But again, based upon what is a clear bond violation, and because I found you in clear indirect criminal contempt of court, it is my order that you will serve 10 days in the Otsego County Jail. You will turn yourself in today, which is the September 6th, 2023. If you don't turn yourself in by no later than 4 p.m. today, then I'll consider that additional bond violation. And as you probably know from our discussion today, if there's an additional bond violation, then I will treat that on its own. An additional bond violation could mean that I revoke bond altogether, could mean that I raise bond, it could mean that I treat it as indirect criminal contempt. All of those things are possible and you should be aware of them. So 10 days is the order for the indirect criminal contempt. Upon the 10th day of your sentence, I will reinstate your bond, subject to all prior conditions. Do you have any questions about those orders, Mr. Cooper?
I need to build my life for my kid, man.
Mr. Cooper, your choice.
Oh my!
I'm his mother. I was on the phone with arrested.
He's heading up. That dude scared the hell out of me. I can see how he rages on his old lady now. God, man, let's run it back.
I need to build my life for my kid, man.
Your Honor,
Mr. Cooper, your
I
choice of
can't lose
words
my job.
I'm his mother. I was on the phone
that
with
is helpful to
arrested.
He can't lose his job, Your Honor.
Come on, you stay the out of it, dude.
Clearly under the influence of drugs that day that they said he was arrested for this domestic, Your Honor. All
And I
right.
don't know who,
Sorry.
and I'm not going to hear from you. This is not an open proceeding where you are entitled to come in and tell me anything because A, I don't know who you are, and B, this is not an open proceeding. This is a structured courtroom.
Man, oh man, this dude's got a rude awakening coming his way. You ain't no kid no more, bro. Your mommy can't save you, and it doesn't matter if you were on inebriants or not. Change life now or not. It don't matter, man. Sad, sad, sad. Never scream at the judge either. That guy, man, he's definitely going to Smokeville if he's the sentencing judge in the trial.
The structured courtroom requires that I hear from a prosecutor, a defense attorney, and the defendant. I have heard from those individuals. So, ma'am, I'm not going to hear from you despite your desire to be heard. Mr. Cooper, my order is what it is. You will have the choice to either follow it or not follow it. If you don't follow it, there likely will be repercussions, but you get to choose whether or not you follow it. If you follow that order, then it will be much more likely that I would consider different things in the future. If you don't follow it, it's likely that I consider other different things in the future. Because your ability to or willingness to comply with the bond conditions of the court, Mr. makes a difference on a case going forward.
Your Honor.
So that is your order.
I just
I'm
got
going
him
to issue.
to go home. I'm his mother to attend him for court. I got all right.
Again, ma'am, I'm speaking over you on purpose. You don't know who you are, and you're not entitled to be heard on this court record. Therefore, I'm not considering.
And I was going to.
I'm terminating the call now with the order being clear. You need to turn yourself in by 4:00 p.m., Mr. Cooper. If you don't, then a further issue will come up. And again, I may act on an immediate basis if I hear information. Don't turn yourself in by issuing a bench. With that, I'm removing Mr. Cooper and the individual who will clearly not listen to the court direction. And Mr. Trush, I'm going to make then a further record.
Well, there you have it, ladies and gentlemen. 10 days in jail for violating a protective order. And it doesn't matter if the victim's there to speak on your behalf or not. Sometimes these judges just had enough. And also remember, it doesn't matter if you just started a fantastic job. Once in a lifetime kind of deal. And you got a huge family to take care of. Look, some judges, some courts, they don't care. Some of them play by the book, no questions asked. But hopefully you enjoyed today's episode and learned a few things along the way. Stay tuned. Tomorrow, I'm going to be doing a story about an inmate that lost his life inside of an Oklahoma prison. And believe it or not, it all started behind fines. You ain't gonna believe the crazy turn of events in that story, so stay tuned. And the only way to do that's by hitting subscribe and that notification bell, set it to all. But as always, until the next time, y'all be easy, be safe, and more importantly than anything, stay free.